everybody, good afternoon. I hope everybody has been patient with me while I work out my technical issues. I did want to get us started off by greeting everyone and asking everyone to let everyone know that we were planning on trying to have a real meeting today, or I guess you could say a in-person meeting, but we had to at the last minute change our plans, as you know. So we're going to do a virtual meeting today, and I hope everyone will. Some people may be disappointed in that, and some people may be happy about that. So we'll try to satisfy everybody today. First thing we want to do is, everybody got a copy of your minutes, I hope. If you would refer to those minutes, and if there's any changes or comments about the minutes, we would entertain those at this time.
Mr. Chair, this is Jake Golding. I move we approve the minutes.
Okay, thank you for that. And do we have a second?
McKinley, in a second.
Okay, we have a motion and a second to approve the minutes. Any further comments or discussion on the minutes? If not, just as a reminder to everybody, we do have to do a roll call vote. Kim, if you can call the roll, please.
Yes, sir. Calling for the roll, Ms. Betty Budd. Tara Callahan.
Approve.
Darren Campbell. Jay Corpening.
Vote to approve.
Bill Davis.
Approved.
Gary Frank. Beth Freshwater Smith.
Approved.
Michelle Hall. Krista Hyatt. I'm sorry, can you repeat that, Krista?
Approved, yes.
Thank you. Ruby Brown Herring.
Approved.
Jennifer Knox. Billy Lassiter.
Approved.
Jeffrey Ledford.
Approved, yes, ma'am.
Tim Martin. Martin McGee. Carol McManus.
Approved.
Judge Rader.
Approved.
Mary Stansel.
Approved.
Heather Taraska.
Approved.
McKinley Wooten.
Approve.
Eric Zalgrig.
Approved.
Roll call complete.
Okay, thank you for that, everybody. The minutes are approved. Our next item on the agenda is the implementation update, and that would be from Deputy Secretary Lassiter. Deputy Secretary, are you there?
Mr. Lassiter, I'm going to unmute you. There you are, sir.
Okay, thank you. All right, and hopefully everybody can see the screen now. We good, Kim, on your end?
Yes, sir.
Okay, perfect. All right, so I'm going to give you a quick update on implementation, where we are on Raise the Age, and then we will also take any questions that you have. I'll move through some of this quickly because I know it's difficult in these teleconferences to go through slides like this, but feel free, if you got a question, you can drop it in the chat or you can ask out loud. Feel free to stop me as we're going through the presentation, and Kim and Aaron will draw my attention to the chats if y'all have one. So just, I think last time we went over some of the steps that we were taking to respond to COVID. These are the steps that have been taken at our youth development centers to protect us from our kids from COVID. I'm just putting that in to remind everybody that we're still in the middle of the pandemic, obviously. And as Bill said, we wanted to have this particular meeting in person, but as you all know, the executive order by the governor, I think it was last week that he issued, limited gatherings to less than 10 people. So we did move to this virtual setting again for this. But we are taking lots of steps in our facilities and in our court services offices across the state to keep our staff and our juveniles and their families safe during COVID. We've been extremely fortunate, knock on wood, that we've had few cases in the juvenile justice system of COVID, and currently have no active cases in any of our detention or youth development centers at the current moment, active cases among our juveniles. So we're really proud of that, and our staff have worked extremely hard in difficult conditions, wearing a lot of that protective gear that you see nurses and doctors wearing, and a lot of times in shifts that last for 12 hours. And so I just really want to applaud the staff across the state that have done the hard work of making sure that our kids and our public can be safe from this virus. So these are the steps that we've taken. I won't go through each of those, but you can see them up there. A reminder of the budget. We did get the budget funded for Raise the Age, and you all have seen this slide a number of times. We did ask for additional funding at the end of the legislative session to try to get additional money for detention. I'll go walk through why that's important in a few minutes, because we have seen those numbers start to grow some, and we got about half of what the request that came from JJAC was for detention. So you can see we got quite a bit for detention, but there was half of the request that came from this committee for detention. And as we've taken on the additional kids of the House Bill 593, in addition to the Raise the Age kids, that number in detention has been growing. So we are still asking for those resources, but we've been working really hard on hiring all the court counselors, getting the services up and going across the state for community-based programs, and those things have been moving along. Obviously, it's more difficult to get new programs started in the middle of a pandemic, such as transitional services or residential programming especially. To get those facilities licensed in the middle of a pandemic has been very difficult. But we've been fortunate. We've gotten 2 brand new facilities that are up and going. One that's providing transitional services in Forsyth County. This is another male transitional bed facility. I'm really excited about that facility being up and going. It's for kids that are transitioning out of youth development centers or other residential placements. It's for the older population, and while the kids are at that transitional facility, they're getting jobs, and they're also getting enrolled in the community college system. And so some of that's had to be online because of the current situation that we're in, but the kids are going out and applying for and getting jobs, and really excited about the experiences that they're getting at that new home. And then we opened a brand new facility also in Union County, just east of Mecklenburg County in the city of Monroe. I'm really excited about that program. It's a 12-bed facility, and it already has kids in that facility. We have a multi-purpose for that facility. It's both transitional and is providing kids that need short-term residential facilities a bed, and it's also providing DSS a bed in that facility. So kids that are runaways or kids that are involved in DSS custody that need a bed are also getting served in that program. So this is one of those first really multi-purpose and multi-agency experiences that we're working with on that transitional facility in Monroe, North Carolina, and really excited about getting that facility up and going. We've also got some detention centers that we brought on, and I've got some more information about those as I go through the slides. But these new residential programs we're excited about. We also just expanded the capacity at the Vance County facility for females up in Vance County, North Carolina, that serves females statewide that are in residential care. Eckerd is now the provider for that. They took over providing the service on September 1st. And so that's a new service. It's an extension of what we used to have, but additional beds and a new provider that's providing those beds. So we're excited about that change. So that shows you a couple of the things that are going on as far as the budget requests. We've got most of the court counselor positions hired now. We still have about 17% of vacancy rate in the court counselor position that we're still working on hiring those positions for. And so we still got a little work to go, but a lot of those positions have been hired across the state and are up and going and going through training now or have been brought on and are working in those positions. So y'all have seen this slide several times before. This is what we projected would happen with Raise the Age. This is the population that we thought would come into the system. And so let me show you what actually has come into the system so far and what we're seeing. So this gives you, dating back to January, there's three colors here. The red bar is the number of kids that are complaints that have come in that are non-RTA. So these are kids that are younger than 16 that are coming into the system still. The blue line, or the blue bar, shows you the number of Raise the Age population that's coming into the system. And the green line shows you how many complaints we got into the system last year. And so you would expect that the red bar and the green line would match up. And then the blue would be on top of that because those are additional kids that we didn't have last year before Raise the Age. And what you can see here is that for the first couple of months, that was true. In fact, the red bar was a little bit higher than the green bar. So we were actually seeing more under 16-year-old kids coming into the system than we did the year before. But those are the only 2 months this year that has happened. In fact, every other month we're seeing significantly lower numbers of kids under the age of 16 coming into the juvenile justice system. And in fact, in May, you can see there, we actually had fewer kids come into the system for both Raise the Age and non-Raise the Age population than we had last year just for the non-Raise the Age population. So that is a significant point. And I think this is unlike what we'll see in any other year because what we've seen is that COVID obviously has affected these numbers. With kids not being in schools, those numbers have definitely changed, and we'll talk a little bit more about that as we go through the presentation. So as actual percentage change from last year as far as the number of complaints coming into the system, you may remember that we projected about a 60% increase in the number of complaints that would come into the system based off of Raise the Age. And in the first 2 months, we had more than that, in fact. In January, we had 71%, and in February, it was at 63%. But most of the other months now have been below what we projected or right at what we projected. And you can see in July and August, the numbers started to really come back to what we were expecting. And now we started to see a decrease again in September and October in those complaints. But again, May is really interesting because that shows you that we actually had fewer complaints come into the system this year than we did last year, even with the Raise the Age population. But that's just a 1 month phenomenon. You can see the rest of the months have seen an increase, and some of those pretty substantial increases. As far as school-based offenses, as you know, we've been working on the School Justice Partnership and talking about that a lot. Obviously, with COVID, school's been out most of the year since March. And you can see that those numbers have significantly decreased. So the red line here is the number of school-based offenses the year before. The blue line is the number of school-based offenses that have occurred this year. And you can see that the numbers still have not come back. And with school-based offenses representing, 40% or 40 to 45% of the complaints coming into the system, obviously that's driven down the numbers across the state. And so we don't think that this year is representative of what we'll probably see in future years. As far as a breakdown of what we're looking at as far as what types of crimes are occurring, we are seeing more serious and more violent crimes than we have in years past. And as a proportion of the total number of crimes that are coming in, the very serious crimes are still a very small portion of the crimes coming in. The serious crimes have grown, though, and you can see that in this chart here as you move through the months that those numbers have increased as a comparison to the year before, and then overall have increased, but not a huge amount except in a couple of those months there. The other thing that we're looking at here is the under 16-year-old population. Those crimes have decreased significantly from last year, and you can see in each of the categories how those crimes have decreased. So almost a 50% decrease, for example, in Class A1s for juveniles under the age of 16. And so it's really the population over 16 that's driving any increase in the juvenile justice system, because the under 16 population has decreased. And so these numbers are interesting comparison to the year before, and you can see how they have dropped. We think that's obviously related to COVID with the closure of schools. The courts were closed for a little while, but we've got hearings up and going, especially for detention and meeting all those constitutional requirements through video conferencing, and that's gone really well. We've done video conferencing, and video conferencing is available at all of our facilities now, and that's made a huge difference in our ability to get kids to the courtroom without having to transport them and exposing them to possible COVID exposure, and then bringing them back and having to put them in medical isolation until we're sure that they don't have COVID. So we're really glad that technology is available to us, and we're using that statewide now. There's been a decline in the complaints of status offenses. Status offenses, the top ones typically are those things like truancy, and so with kids not being in school, we've seen very few truancy complaints, although we know from a lot of the statistics that we're seeing from DPI that there's quite a few kids that are not attending school. I was on the Child Fatality Task Force meeting the other day, and we've gone from an average absentee attendance on virtual academies from what we had last year was about 4% on average. This year we've been as high as 15% average absentee attendance from schools. And obviously COVID is causing some of those issues, along with the trying to do it virtually across the state. So that's been a real difficult situation for our schools and our kids across the state. We're having higher numbers than we projected of the A through G population. And so there's a question about what's causing that. This is in comparison to the year before, when we compare what 16 or 17-year-olds were being charged with the year before versus what they're being charged with this year. We're seeing significantly higher A through G complaints for that population. And so the question is that a nature of the legislation that required those kids to automatically be transferred? Is it that we're starting out with higher offenses to make sure that they don't need to fall into that transfer bucket? And so we're trying to figure out those numbers now, but that's an interesting trend that we want to keep an eye on. This shows you the school-based offenses for the last 10 years, and you can see this is the under 16-year-old population because we didn't track the over 16-year-old population before. But last year we were sitting right at 45% of all juvenile complaints came from schools, and obviously this year with COVID happening has dropped to 19%. So we've gone from 45% to 19% of the total complaints coming into the system are school-based. And you can see the comparison here. So we've had 24,239 total complaints so far this year in comparison to last year, where we only had 17,000. And of those 24,000, 4,639 have been for school-based offenses. In comparison to last year, we're of the 17,000, almost 7,000, almost 8,000 of those complaints were school-based complaints. So a much smaller percentage of these number of complaints coming in are school-based offenses. However, we're still seeing, if you compare year over year, almost a 7,000 complaint increase in coming into the system, and obviously that's because of Raise the Age, additional kids coming into the system. So we projected about a 60% increase, and that 24,000 is just year to date. We'll see what the year ends up with. I can tell you that although 24,000 is significantly higher than that 17,000 that we see down below, it's still not as high as what we saw back in 2000, for example, where we ended the year with almost 44,000 total complaints coming into the juvenile justice system. I don't think we'll end anywhere near that high of a number by the end of the year, but we'll see what the year-end data tells us. The other thing that we've noticed during COVID is that we've seen fewer of those disorderly conduct type charges and a lot more property crimes during COVID. Now, that could be a nature of the kids not being in school and not being charged with disorderly conduct as much in school, but it's also true that we know that kids are suffering and families are suffering, and they're getting and needing more resources for their families, and unfortunately they're finding inappropriate ways to get those resources, and I think that's what is contributing to some of this property crime increase that you're seeing during COVID. This shows you the overall trends as far as what we're looking at, and a comparison before COVID and after COVID. And if you compare we were right at 57% of the total number of complaints coming into the system increase over the year before COVID. We projected 60%, so 57%, that's just about dead on what we projected. And so we feel really good about that number and feel like that really truly represents what we thought was going to happen. And then if you look at April through June, where COVID was hitting the first peak in the state of North Carolina, we only saw an 18% increase in juvenile complaints coming into the system. So a huge drop off during those months during the COVID time period. So will we be closer long term to the 57% or closer long term to the 18%? I think time will tell, but it does appear that when all things were normal, the projection that we made was pretty close to what we ended up having in the system. Interestingly, although we've had additional complaints coming into the system, we haven't seen a huge increase in the number of admissions going into our detention centers. And so you can see here the comparison to the year before and to the present year. The year before is the pure orange bar that you see there, and then you can see the comparison to year-to-date this year. And you can see the yellow there represents, or the golden color represents the number of raised the age population that's coming in to the detention centers, and the orange bar is the under 16-year-old population going into detention centers. So we've seen a significant decrease in the number of under 16-year-olds going into our detention centers, and that's largely due to the fact that we've been trying to limit the population in our detention centers due to COVID. We've come up with some innovative techniques across the state to really try to reduce that population, to do more electronic monitoring, to do more alternatives to detention, and have been very successful with that. So you can see that that's driven down that population. And you remember earlier I said that we needed additional funding for detention. And you may ask, well, why do you need additional funding for detention if your admissions are going down? So let's dive a little bit deeper into the data, because I think it's important for you to understand this moving forward. So as far as the detention population itself, the population has been rising. So how has the population been rising when admissions have not been rising? That admissions are almost constant from what we saw the year before. The biggest reason is that we're holding the transfer population in our juvenile detention centers now. Those A through G population that are getting transferred to adult court are staying in juvenile detention and not moving to jails, and those kids are staying much longer than the average juvenile in a juvenile detention center. And so that's driving the population to go up in our facilities, because those kids just aren't leaving. They're waiting for their trials. They're waiting for the final sentencing or conviction, or the being found not guilty in those cases and being released. And so those numbers in our actual juvenile detention centers have been going up significantly. We've seen a 59% increase in our average daily population in detention. So that is obviously a very significant change in our detention population. And as I said, what it was driving that, you can see on the next slide here that the line on the top shows you the percentage or the number of kids that are transfers to adult court. So that number started out at the beginning of the year at 20, and now we're up to 45 kids that are transfers to adult court. So we've seen over 100% increase in the transfer population over the last 9 months in our juvenile detention centers. And so that's driving, again, the population in our juvenile detention centers. And it's just a very different population than what we've had in the past, or we had kids that were in awaiting a juvenile hearing, and these kids often, they don't have to be reviewed for 30 days, and a lot of them are awaiting trials that are taking a year to occur. And mainly because they're facing very serious offenses in those investigations, and the attorneys need the time to make the right calls on those cases. So as a percentage of the actual detention population, you can see here that we're talking about it's grown from just over 10% to over 20% of our population are now the A through G population that have been transferred to adult court. The other thing that I'll add to that is this is after they've been transferred. So once the transfer process has occurred, that means that they've gotten the probable cause or the indictment process has taken place, and they've actually been transferred to adult court. That's when this kicks in, that we start to look at that population. As you know, there's quite a few kids that are A through Gs that are pending that indictment or probable cause. That's not even included in this number. And so that as we recommended to the General Assembly and they put into legislation last year, our district attorneys and our defense attorneys have longer to make that determination whether to do probable cause or indictments on those kids, and it's taken longer. And so we're trying to get our hands wrapped around exactly how long those kids are in and how many of those kids are in that are A through Gs that have not been transferred yet. They're still waiting on that probable cause or indictment to come down to see how that contributes to this population. But the thing to understand is that although admissions have not increased, the length of stay of the kids that are in our system now has increased. And because that is increasing, our population in the facilities is increasing. So overall, we're seeing that kids are staying at least 2 days longer in our juvenile detention centers, but I think it's actually much longer than that. One of the reasons why that number hasn't fully adjusted yet is before we can calculate an average length of stay for those kids, they must have an entry date and an exit date. There's a lot of those A through G population that haven't exited yet. They've come in since December. They've been transferred to adult court, but they have not exited because their case has not been heard yet in Superior Court. So they're still sitting in our juvenile detention centers. So that number has not added into our average length of stay yet. So it's going to take a year for us to really understand exactly how long these juveniles are staying in our juvenile detention centers, and for us to get a good idea of what that's causing to occur in our facilities. So the percentage of intakes, when we look at intakes coming into the system in the past, before Raise the Age, about 8.2% of our kids that were brought in for any type of charge to the juvenile justice system would get detention. That is slightly up with this older population. We're almost at 10% now, 9.8%. So that is up. Also, we're seeing that these kids are more likely to be detained than the younger population. And we're seeing that there are more complaints per juvenile than we expected. It is 2.3 was what we saw in the past, and with this older population, it's 3.1 complaints per juvenile that comes into the system. House Bill 593, which was a recommendation of the JHAC and passed the General Assembly in July and went into effect on August 1st, has created, this is the population that was under, it can be under adult supervision that were currently kept in the jails, now have to be kept in juvenile detention centers. And so this is for kids that may need a quick dip in the adult system. They may be in for those DWIs and get a sentence in a local confinement facility, which is now a juvenile detention center. And so you can see the numbers here. It's not been a huge number, but it is a significant number that we have to take into account and really make sure that we have the bed space for those kids moving forward. And you can see that we're talking about overall, it's been a total of that 25 that have concluded, and we have 8 currently active in our jails in our detention facilities right now. So we have increased the capacity in our juvenile detention centers. When we started this whole process, there were 133 beds for that we projected that we were going to add into the system, and you can see what we've done so far. We entered it with 190 beds statewide that were available. Of those, 132 were state beds, and The other ones were operated by the county. We've moved from 190 beds available statewide to 323 beds available statewide. So we have made significant progress in opening additional beds across the state to be available for this juvenile detained population. 178 of those are now state-operated beds. We just added Brunswick County on Monday, and so they took their first kid in on Monday morning, and so they have 12 additional beds down in Brunswick County. That's a new juvenile detention facility. And we, as you all know, we also added Mecklenburg and Madison to those numbers. And we're also currently renovating C.A. Dillon to have capacity there, and we got money to renovate Clemens Juvenile Detention Center also. And so we are adding to capacity so that we can take in this longer staying population that we're seeing in our facilities. And although we got the renovation dollars, we didn't get additional dollars to staff those facilities. And so that's why we're asking for that additional $6 million to staff those detention facilities moving forward. One other thing that I really wanted to tell you about that we're really excited about is that we're adding a new tool in the juvenile justice system that's called YAZI. This is a tool that's used in a number of other states across the country. This has been a process that we've been working on for just over 5 years now. We started out by looking at all the risk and needs assessment tools that were available across the country. We had our juvenile court counselors come in and look at each of those different tools. We had a working group of about 30 people come in, review each of those tools, and they determined by far that the YAZI was the most user-friendly tool that we have. So we looked at that and chose the YAZI. It's going to add a lot of information that we haven't had in the past, and we're really excited about it. One of the big additions to the YAZI is that it doesn't just look at risk and needs, but it also looks at the strengths of the child, so that we can figure out programming that will work for that child that acknowledges their strengths moving forward. So we got internal and external training that's currently occurring on YAZI, and hopefully you've been invited to one of those trainings if you are part of the judicial system. We're really excited that we've had over 750 stakeholders already apply to be part of those trainings. We've had judges, we've had legal staff, we've had DAs, we've had defense attorneys all attend these stakeholder forums. And actually, we've had more people that want to join than we have slots, so we've added a couple of additional trainings coming up in November and December. But the overwhelming reaction to it has been very positive by folks across the court system, and I think this is going to be a much better tool to give you guys information to make better decisions for our court counselors, but also for our judges and our DAs and our defense attorneys to make better decisions about what services are really needed for a child moving forward. We're also training our community-based providers on it so they can interpret the data that's coming from it. It's a state-of-the-art tool. Again, it looks at needs of the child. It does that full risk and needs assessment and adds the strengths component to it. It's tied to our service directory. We developed that service directory we presented to you guys on before that lists all the programs that are available across the state. Well, the YAZI is going to match the risk and needs of those child that is being interviewed by that court counselor with the programs that actually serve kids with that identical type of profile. And it's going to tell the juvenile court counselor at the end of the process, these are the types of programs in your area that would best serve this child moving forward. And so we're really excited about this. It's going to really allow us to do better service matching with our kids, which the data has shown overall can reduce recidivism for young people by over 50% if you match the kid with the right service at the right time. And that's really what YAZI is going to allow us to do in the long run. So the goals of it is to provide that service matching for our court counselors and to provide those recommendations for the judge moving forward. These are the domains that are captured in the YAZI. So many of the things that we're used to capturing on the old risk assessment tool are still going to be captured, but just much more in depth. So we're still going to look at school behavior, aggression, their peer relationships, their adaptive skills, their family, what's going on with their family, attitudes that they have towards criminal behavior, and what are they doing with their free time. And so you can see that those domains are really important. These were ones that were already part of the OSSI, and we, as a department, asked to add a couple additional ones that we wanted to know about so that we would know if we needed to help a kid get these things addressed. And the things that we added to it were basic needs, so that we could ask about, do they have food in the house? Do they have proper housing? Do they have the materials that they need to be successful in school? Do they have proper clothing and those types of things, so that our staff could help work with other services that are available in the community to help that family address those needs if they're present. We also wanted to look at physical health, because we often know that physical health can drive a kid to be thrust into the juvenile justice system if their basic physical health needs are not being met, such as things like medications and dental and vision appointments and those types of things, making sure that they have the proper hearing equipment if that's necessary. So we added those additional questions to the OSSI so that we could make sure that if those were some of the basic things that were causing the kid to be driven to the system, we could help them get those things addressed also. So as I was talking about earlier, the features of the OSSI, one that's very different than what we've had ever in the past is that it addressed strengths. And we're really excited about this because we want to know what are the things that the kid's really good at. What can the kid perform well in, and what should we be helping them? How do we prod those interests that they have? If they're really interested in auto mechanics, or if they're really interested in fiber optic cabling, making sure that we can make a connection for them in the community with those types of services. So we wanted to look at their strengths and see if we could address those things also beyond just looking at the risk and needs of the child, but really find out what are they good at and how do we encourage that to occur in that child's life. It is gender and racially responsive, and so we're excited about that as we really try to reduce our disproportionality in our system. We want to really look at making sure that we are looking at those equity issues as far as gender and race and ethnicity. So that is a feature of the OSSI. It also addresses trauma. It looks at the ACEs, and so we're excited about that. It adds that component to our current risk and needs score, and really looks at making sure that's part of the plan moving forward. It's responsive to the needs of the child, and we use motivational interviewing, which we trained all our juvenile court counselors on to do the process of asking these questions so that we get better responses and do better service planning with that child and their family moving forward. And it measures change. I think that's the big difference between this tool and our old tool, is that our old tool was very static, meaning that once you got a risk score, you only had that risk score or a higher risk score moving forward pretty much. You couldn't really lower your risk score. And with the OSSI tool, once you've been through a program and you've been through a service and you're showing progress, this tool will show that progress. It will actually show that your risk score drops over time if you're doing well in those programs and are showing new behaviors that are appropriate. Your risk score will drop, and that gives us a better indication as the department when we're making determinations, for example, about when to release a kid from youth development centers. If that risk score is dropping, then we'll know that this kid is a kid that should be eligible and has a good chance of being successful once they get out of the facility. And so we're really excited about the dynamic scoring of this risk instrument moving forward also. So overall, and we'll send this PowerPoint out to all of you because I know that data is a little tough to see, but we do have it broken down by district as in our normal dashboard that you can see here. Again, the projection versus what the real number is, the blue bars being what we projected, the yellow line being what is actually coming into the system. And so it's really interesting that some of our bigger urban districts where we projected higher numbers, we've been about half of what we projected in those urban counties. But in our rural counties, the yellow line is matching up almost to the top of those blue lines. So they're seeing almost exactly what they were projecting in those counties. So it's really been the urban counties that have kept us from seeing that 60% increase that we were projecting. Most of our rural counties, they're seeing pretty much what we were projecting for those particular counties. So that is the number of complaints, and this is the number of juveniles coming into the system. And so you can see the overall number of juveniles coming into the system 3,880 additional kids that are coming in because of Raise the Age this year. And you can see the breakdown for the A through Gs there. Of that 3,880, 557 have been those kids that have been A through Gs. And so it's not an insignificant number, but it is still, that means that, you know, a large portion of those kids that are coming into the system are not getting transferred to the adult system and are staying in the juvenile justice system moving forward. So just as a summary of what we've seen with Raise the Age, we've seen that a 44% increase in those delinquent complaints that have been received, or the Raise the Age population makes up 44% of the population coming into the system. Of those 3,424 distinct juveniles have come in 2021 so far. 55% of those complaints were for minor offenses, 36% for serious offenses, and only 8% for violent offenses, compared to 5% for the under 16-year-old population. So it is a slightly higher, about 3% higher for this older population, but still the vast majority of the offenses, 55% are for misdemeanors or for minor crimes. And so I think it's really important to keep that in context as we look at the numbers moving forward. These kids tend to be higher risk, as you would expect, and we are still doing quite a few diversions and closures with this population for those kids that are not the A through Gs, but the H through 3 misdemeanors. We are diverting a higher population than we projected that we would divert, which I think is a really good sign. And early data on that, and you know, it's obviously very early in the stages, but those kids that are on diversion plans or contracts that are 16 or 17 years old are actually doing really well. They are not recidivating at high levels at all. For the kids that were put on diversion plans or contracts, this was the population that Raise the Age was really about, making sure that that population that didn't need an adult record, that could have a light touch to the juvenile justice system, get an appropriate service, plan or contract, put that plan or contract in place, they complete that plan or contract in that light touch to the system, and be successful moving forward with the rest of their life without having an adult record. And what we're seeing is that we're seeing quite a few of those diversions across the state, higher than what we projected, and those kids that are on those diversions are doing better than we thought they would even do. And so those are both really good signs for this population moving forward. All right, so I'm done with my part. I'll be glad to take any questions that people have about that presentation or any of the things that are going on with implementation.
Any questions or comments from the group?
Billy, this is McKinley. Thank you for your presentation. I had a question early in your presentation. You talked about, and I'm not going to get the name right, more transitional type programs that are in place and assisting some of the older youth with kind of transitioning and jobs. For those kids, that young people who don't have family supports left, are there any attempts at mentorship with adults in those areas as well?
Yes, McKinley, good question. So the transitional home that we just started in Forsyth County is in addition to one that we have in Craven County already. And the Union County one is also going to have beds that are available for transitional services. But we're also working with youth villages to do a program that's called Life Step, which is for this transitional age population, where they partner them with a mentor and someone that also works on any mental health issues that may be going on with the child, but really works with them on transitional services. We also have several JCPC programs that are available that allow for that mentoring population. In a lot of our districts across the state, mentoring is one of the top programs that are funded through our JCPCs. And so we're working with our JCPCs across the state, our juvenile crime prevention councils across the state right now, to really think through how do you change that mentoring relationship for an older kid, and getting some training available to those program providers across the state so they can do that. But we are trying to expand those services now because we know with these kids that are going to leave YDC, they could be 18, 19, or 20 years old. And that's a very different population and often the family doesn't want them back in the home. And so trying to figure out how do we make sure they can be successful when they leave that home. And DSS isn't going to be involved with them anymore. So a lot of these kids are trying to figure out, where do I go when I get out? And so we're trying to establish those services with them.
Okay, thank you.
Thank you.
Billy, this is Ruby. I have a question for you.
Yes.
For those more serious crimes that you're seeing the increase in, is there a geographical trend as to where they're happening, or are they pretty much even spread across the state?
That is a good question, Ruby, and I don't know off the top of my head.
Okay.
I do know that we've seen the biggest increase that we've seen in serious crimes has been robbery with a weapon.
Okay.
And we're seeing across the state, especially in Durham and Forsyth counties, in Mecklenburg County and Guilford County, we've seen a lot of increase in gun crimes, gun-related crimes. And the reality is that we've seen a huge increase in permitted guns across our state also. And just a hypothesis that I have, I don't know if it's accurate yet or not, but a lot of people that didn't own guns in the past are buying guns now, right, and not properly storing or securing those weapons. And for a juvenile that sees a gun sitting out on a front seat of a car, that's a $600, $700, $800 weapon. That's an easy way to make some money on the street. And so we've seen a big increase in kids stealing weapons from cars that aren't secured in a glove compartment or any type of safe or anything like that. They're just stealing them right off the seat. And we've seen a big increase in those. And that may be leading to some of these other armed weapon charges that we're seeing down the road. That's just a guess. But we have been specifically targeting Durham, Guilford, and Forsyth County for some additional services because they came to us and we specifically looked at their gun-related crimes and saw that there were increases in those counties. So we're trying to do some targeted outreach and programming in those particular counties and doing a new Project Ceasefire program in those counties to really target kids about why guns are dangerous and what's the proper use of those and have really we're working with those local law enforcement agencies and also other JCPC providers to address that issue with our kids in those areas, trying to drive down those gun-related incidents.
Okay, thank you. I was thinking it may have been related to Forsyth and Durham, but I just was trying to see if there were other areas. I appreciate the answer.
Absolutely.
Billy, we have a question from the public about the Yazzie. They're asking at what point the Yazzie will be used. Will it be used at intake or at some other level of intervention?
Excellent question. So Yazzie will be used for when kids come on in intake, they'll do a brief version of the Yazzie that's very similar to the risk and needs assessment that we're currently doing in the system. Only when they move farther into the process and get approved for court would they go through the full Yazzie. And so they'll get the brief part just for that. If we decide to dismiss or close or divert that case, they'll only do that brief assessment of the Yazzie. And then as they get deeper into the system and go to get approved for court, we would do the full Yazzie with them. Did I answer that full question, Kim?
I believe so, yes, sir.
Okay, any further questions or comments from the group? Well, thank you for those questions, and thank you, Deputy Secretary, for the presentation. Sounds very positive in a lot of areas that I know that you've been working very hard on, and this group's been very concerned about.
Thanks, Bill.
Next on our agenda is the subcommittee report outs. First, we have hopefully I have Heather Taraska. Are you there, Heather?
Heather, would you like me to try to unmute you?
I'm sorry, I thought I was speaking. Hey, everyone. Can you hear me now?
We can, Heather.
Okay. It's my understanding that we adjusted the meeting time so that Jackie Green could report out regarding the recommendations that we voted on at our last subcommittee meeting. Jackie, are you with us?
I am with you.
Wonderful.
I'm wondering, Kim, if you want to pop the document that has all the language in it up.
Yes, ma'am, will do.
That would be awesome. So I was helping this subcommittee pull together some suggested language that would address, most of it is focused on addressing the issue that most of the changes in the original legislation did not anticipate that young people who commit A through G offenses at ages 16 or 17 could actually ultimately end up back in juvenile court. And if you recall, that was kind of a late game changer in the amendments that happened right before implementation. Was there is now this ability when the prosecutor and the juvenile's attorney agree that the case must actually be remanded from Superior Court back to the district court. So there's this reverse waiver possibility, which could mean that somebody who commits something that is in the A through G range at age 16 or 17 could actually ultimately end up adjudicated delinquent instead of convicted in Superior Court. And the original legislation didn't really anticipate that. So what we have for younger kids and have had for a long time is this ability, if they are adjudicated delinquent for a serious felony and committed to the YDC, there are these extended commitment periods for them. And so young people who commit their offenses under age 16 can sometimes actually be held in the YDC until they turn 21. We didn't have those similar extended commitment provisions in the original raise the age legislation. We still don't have it. So a lot of these changes are about creating the capacity for those extended commitments for 16 and 17-year-olds if they are adjudicated for these more serious felony offenses, which, of course, under the structure we have, would only happen following a joint motion to remand the case from Superior Court. Kim, do you think you could scroll down to the charts? Because I think that's probably the best place to start, and then we can get back up to that. Thank you so much. So these charts are in here not because we're suggesting that they go into the statute, but because they're the only way I can think about this with a clear mind. So I thought I would share them with you. You see the second chart are the regular jurisdictional limits. So for most offenses, the way the statute is written right now, if you commit your offense under the age of 16, you age out of juvenile court jurisdiction when you turn 18. If you commit your offense at 16, you age out of juvenile court jurisdiction on your 19th birthday. And if you commit your offense at 17, you age out of juvenile court jurisdiction on your 20th birthday. So those rules are the rules for 16 and 17-year-olds right now in the statute. There's no capacity to extend jurisdiction beyond the 19th birthday or the 20th birthday for 16 and 17-year-olds. And ironically, if you're under 16, there is already capacity to extend you up to 21 for certain offenses, and for other offenses up to 19, which is one extra year. So we have this bucket. If you look at that top chart, in the first row, or the second row under the headings, in that chart that says extended commitments, and it says age of offense, any, offense type, and you see these offenses listed. So these offenses, first degree murder, first degree forcible rape, thank you, Kim, first degree statutory rape, first degree forcible sexual offense, or first degree statutory sexual offense, those are the offenses right now. In the statute, if you commit them under the age of 16, you can be committed to the YDC up to age 21. That's the existing law for the under 16s. We didn't map that on to the 16 and 17-year-old offenses because we didn't think that they might end up in juvenile court, but they could theoretically end up in, I mean, realistically for these offenses, would they? Maybe not, but theoretically at least they could. And then you see the rest of the chart talks about the B1 through E felonies. So the under 16s, for the B1 through E felonies, they can be committed to the YDC until they turn 19 right now. So you notice that's one extra year. The regular rule for them is 18. But if they're committed to a YDC for a B1 through E, they can be committed until they turn 19. They have an extra year there. Again, we don't have anything in the statute for 16 and 17-year-olds to accommodate that potential extended commitment period for a B1 through E. So what you see in that top chart is what this language that we're going to scroll through will do. It will create, if you commit one of those bucket of most serious offenses at any age, you could potentially be committed up to age 21. You could have an extended commitment to age 21, no matter what your age of offense was. The under 16 B1 through E stays just as it is now. They can be committed to 19. And then for the 16 and 17-year-olds, we tack on an extra year for those B1 through E. So just like if you're under 16, you can get an extra year. If you commit a B1 through E at 16 and get committed to the YDC, you could now get an extended commitment until you turn 20, instead of the way it is right now, you would have to be released when you turn 19. And at 17, again, it's an extended year. Right now, you would have to be released when you turn 20. You would get an extra year of an extended commitment for B1 through B and could be held until you're 21. So that extended commitment structure doesn't change anything for the kids under 16. That's what they have now. But it would put that same structure, basically, that we have for the under 16-year-olds in place for the 16 and 17-year-olds in the event that their cases get remanded and they end up being adjudicated delinquent and sent to the YDC. So that's the framework. If we could go back up to the top, Kim, I will quickly walk you through what this language does, and then if it's confusing, let me know. So this first section is just putting these extended commitment periods into the statute. You'll see a bunch of added language there for the offenses committed at age 16 in A2 and for the offenses committed at age 17 in A3. And that's putting those timelines that were in that extended commitment chart into statute. 21 for that bucket of most serious offenses for all of them. And then for the B1 through E's, it's an extra year for each of them. And then, of course, they have their, for everything else, it's just their regular, the regular time frame that they age out of jurisdiction already, which is 19 or 20, if you were, depending on whether you were 16 or 17 at the time of your offense. So that's just kind of putting that chart into the statute for the extended commitment period. All right, Kim, let's scroll down to 1601, 7B 1601. Thanks. This is really just a technical correction. This is where the age limits on jurisdiction lie for the 16 and 17-year-olds, and it didn't accommodate for any kind of different rule. And so this says, you know, except as provided otherwise in this article, it's accommodating for those extended commitment periods. And that is the same language that we have in this same section for the under 16-year-olds that accommodates for the extended commitment period. So it's just making sure we've got all our I's dotted and T's crossed there. If we go down to 7B 1602, again, this is putting those same extended commitment periods into the statute that talks about extended jurisdiction in certain circumstances. So this is, again, just putting what you saw in that chart right into the statute. Okay, so those are all the changes that create the extended commitment periods that were in the chart. I'm just going to take a quick pause there and see if there are any questions about that.
If I could ask, this extended jurisdiction would only apply to offenses that occur on or after the effective date of this if it passes. Is that right?
You know, we didn't write an effective date when we drafted this language, but that is pretty much the way we always write effective dates for legislation like this. So my working assumption is that that would be the case.
Thank you.
Any other questions?
And Jackie, just let me add real quick explanation of it, and just so that people understand the reasoning behind why we did this. You gave a lot of that, but just the other side of it is we're seeing a lot of kids that prosecutors are saying they want to remand back down to juvenile court, but they want to make sure that that juvenile would be able to stay enough time in YDC that they can meet the needs of the victims that are in those cases. And so that's the other justification here, is to open the door to some prosecutors feeling more comfortable also remanding cases back down to juvenile court if they think that's a better placement for the kid.
And just to build on what Billy said, the only mechanism prosecutors have now to keep a case in juvenile court without doing the transfer in the first place is to agree to a lesser charge. And certainly you cannot agree to a lesser charge and transfer and then remand it. And that's a whole nother topic for conversation someday for this group, because it creates, yes, as Judge McGee knows full well, creates a lot of paperwork and process to move a case right back to where it started, and the court has no authority to say no to that under the statute. But sometimes if you reduce those, depending on the kid's history, if you reduce those charges to something less than a G, they might not be eligible for a YDC commitment. And so sometimes prosecutors don't want to agree to the lesser charge because they think the appropriate disposition is YDC, but they can't accomplish that without actually first triggering the transfer. I know I've heard Heather talk about that too, that's another reason why prosecutors are interested in being able to retain these cases in juvenile court on these higher charges with the potential extended commitment period at the YDC.
If I could say, Billy's point is why I asked that question, because, for one, I don't know if we could extend jurisdiction for crimes that are already pending, but if we were able to do that, that might make prosecutors more comfortable in making those decisions. And so that's why I asked that if we can do that and don't do that, then we're going to have a gap of cases that are going to be treated differently because we didn't foresee this. And I don't know legally if we can change the jurisdiction for how long somebody could stay in there if the offense has already been committed before the effective date of this law. I doubt that it could, but I don't know that. That's off the top of my head.
I kind of doubt that it could too, because I think there are a lot of due process concerns about that, right? If you're changing the potential punishment that somebody's facing, when they're already in process, I think that's super thorny. Eric might have more to say about that, but I would worry about that. I would worry about the legality of that. All right. So if you look now at the post-release supervision planning proposed amendments that are in this document for you, Kim, if you don't mind scrolling down a little bit. So these really are, in my mind, also relatively just technical corrections, conforming amendments that, some of this probably should have been done in the first instance, and more of it needs to be done with potential of extended commitment periods. But we have this requirement in the statute, which you see right on here in this language, that there has to be released to post-release supervision 90 days before before jurisdiction ends over that young person's case. So we already have in law this concept that kids are supposed to get at least 90 days of post-release supervision after they're released from the YDC. But the way this was written, we weren't really accomplishing that for the 16 and 17-year-olds. And then it got a little more complicated because we now need to provide for these potential extended periods of commitment, which just makes the language look a little complicated. But really all that we're doing here is making sure that no matter what the period of commitment is for the young person, if they've committed their offense at 16 or 17, they are going to get at least 90 days of they're going to be released in order to have at least 90 days of post-release supervision before jurisdiction terminates over their case. And so that's what you see here in the changes to 7B 2514, sub 3 and sub 4.
And I'll just add, again, Jackie did a great job of explaining this was one that the department's pushing for because we think that 90 days is extremely important so that we have time to work with that juvenile once they're released from YDC, still have 90 days in the community to work with them for the very reason that McKinley brought up earlier when he asked the question about transitional services. If we don't have those 90 days, then we don't have any way to work with that child and getting them into transitional services, getting them matched up with mentors, getting them situated in the community so that they can be successful. So we think this is really important, and the evidence-based proposals that are out there will speak to the fact that this is really important for young people to have that 90 days to allow us to help them adjust back into the community.
All right, Kim, if you want to go to 7B 2516. So this is about revocation of post-release supervision. So now you've been released for your 90-day period of post-release supervision and you mess up and you come back to the YDC. How long can you be held? And the way the statute is written right now, and you can see what was deleted in the comments there, it lines out all the different potential maximum commitment periods for the kids who commit their offenses under the age of 16. And we could have lined out all the potential commitment periods by age again, but my brain felt like it was just easier to put in a cross-reference to the maximum commitment periods. So that's what you see here. Instead of just saying it all again 50,000 more times, it just cross-references the maximum commitment period. So even if you get revoked on post-release supervision, you can't be held beyond, beyond the time that the court has jurisdiction over your case. That's what this language would do. And then if you scroll down to the changes in 7B 2600, this was one that I think was just missed in the original legislation, and now it's slightly more complicated with extended commitment periods. But this is about the court's authority to modify or vacate an order of disposition. And previously, it had just was one little paragraph, and it applied to undisciplined and delinquency cases, and it put everything together. And because now we have all these different potential age limits on jurisdiction, depending on how old you were when you committed your offense and what kind of offense you committed, I separated undisciplined and delinquent kids out. So what will remain in C is what was there for undisciplined kids. It's what was there before. There's nothing substantively changed about that. And what you see in D is the rules for delinquency cases. And again, this just maps on to basically the short of it is the court will have authority to modify or vacate the order of disposition as long as it has jurisdiction over the case. And it just looks a little complicated because the rules are different depending on your age and your offense. I'm going to pause there again to see if there's any questions about those pieces, because then we're going to talk about something different. All right. Billy, do you want to talk about the reasoning behind the detention changes? The post-sentencing, adding the transferred kids post-sentencing to be allowed to be held in detention?
Sure, I could do that. So right now, the process is when a kid gets transferred to adult court, to superior court, and it's an A through G, if they want to be remanded back down to juvenile court, it was unclear if that kid was already in custody under the adult court, under the superior court guidance, because they were an A through G that had already been transferred. If they got remanded back down to juvenile court, how do we get them? How do we get a secure custody order issued for that juvenile while they were when they got moved back down through that remanding process and to be held in juvenile detention? And so we worked on some language to address that, because it's, the process is extremely clear on how that would happen right now.
Yeah. So that's number 5 on your in your document. I can talk you through the language changes here. So, you know, we have right now in the juvenile code, when a case is transferred, the juvenile code tells the district court, once you sign that transfer order, this young person is entitled to conditions of pretrial release, because now, of course, they are a defendant in a criminal matter. Once that case is transferred, it is a criminal case, and you can't hold them under a secure custody order under 7B, because they're not under 7B anymore. They have now moved into the world of criminal procedure law. So we have that already in statute, that those conditions of pretrial release need to be set on transfer. And as we've talked about already, there's now this possibility that the case will come back from Superior Court. It will transition now from a criminal case back to a juvenile case. And we don't have anything in the law that says when it moves from a criminal case back to a juvenile case, if you want to hold that young person, you now need a new secure detention order. We didn't put that in the law anywhere, but we need it. So, because they can't be held on conditions of pretrial release anymore. That's not the court that has jurisdiction over them anymore. So what you see in here, one, is just a change to be clear that the Superior Court, because the Superior Court is the court that's issuing that remand. Just like the juvenile court issues the transfer and sets the original conditions of pretrial release at transfer, the Superior Court is issuing the remand and needs to address the question of a secure custody order if such an order is being sought at the moment of remand. So the first change is just an addition to the jurisdiction of the Superior Court to say that they can issue a secure custody order, but they can only do that pursuant to the existing criteria in the juvenile code for issuing a secure custody order. So if they find that those criteria fit this case, they can issue that secure custody order on transfer. That's what you see in 7A 271. And then you'll see the changes in proposed changes in 7B 1902 is again being clear about that the Superior Court has authority to issue that secure custody order in that one limited circumstance. And then you see proposed changes to 7B 1906. So this is the statute that talks about how often you have to have secure custody hearings. And there was a real interest in the subcommittee in making sure that while the Superior Court can issue that first secure custody order, that young person needs to get back on the schedule for ongoing secure custody hearings in juvenile court. And there was a little bit of concern about the communication and making sure that the juvenile court counselor knows that case has come back and needs to be on a secure custody hearing schedule. So what this language would do would say, okay, once the Superior Court issues that secure custody order, within 10 days, there needs to be the next hearing on secure custody in juvenile court. And after that, the case will be heard in terms of ongoing secure custody hearings according to the schedule for all the other cases in juvenile court for ongoing secure custody hearings. It will get back on the normal schedule. So Superior Court issues the order. Within 10 days, there's another hearing in district court, and then it's back on the regular calendar for ongoing secure custody hearings, as it is in the juvenile code already. And there is also language in here that requires the prosecutor to let juvenile justice know that secure custody order was issued, so that there isn't, that there's some communication there and there isn't a gap, and juvenile justice knows to get that case calendared. Kim, can we just go back up, because I think we skipped over number 4, which is a change to 7B 2204. So this issue is about a young person is transferred, they are convicted in Superior Court, and they are sentenced to go to the state prison system. And we have language in the statute right now that says once that happens, they can't go back to a juvenile detention center. And this would change that language to say pending their transfer to their state prison system place, they can be housed in juvenile detention. I don't know, Billy, if you wanted to say something about that.
Sorry, Jackie, I jumped right over that one last time. Sorry.
That's all right. I got you.
That's exactly right. So right now the statute says once they've been convicted as an adult, they can't be housed in a juvenile detention center. And this is a relic from before the raise the age and the old federal law that basically said you had to have sight and sound separation. If someone had been convicted under the age of 18 as an adult, you still had to separate them from the other kids that were under the age of 18. The new federal law has gotten rid of that. So the new federal Juvenile Justice and Delinquency Prevention Act basically says anybody under the age of 18 must be housed in a juvenile facility, even if they've been convicted as an adult. They must be separated from adults. There must be sight and sound separation of the people over the age of 18. And so there's this relic that's left over in our statute that basically said once that individual will have been convicted and sentenced in the adult court, they could no longer be housed in a juvenile detention center, and that was to keep us in compliance with the old federal law. Now that the federal law has changed and we are housing all kids under the age of 18 in juvenile facilities, this statute now allows us to do that. They typically don't stay that long once they've been convicted and sentenced in the adult system. But we're having this problem right now. We had one just this week where a kid was convicted as an adult, and the statute right now says they really aren't supposed to come back to a juvenile detention center, but the prison can't take them right away because the orders haven't been officially entered into the record by the clerk, and the prison can't take that individual until that happens. And so we are holding them in juvenile detention centers. This basically gives us the authority to do that moving forward. And we are separating those populations in our facilities. We have a facility that's just for this population, and it also has some of our other transfer populations. But this is again a recommendation that came from the department so that we would be able to do that.
So I think we've covered everything that's in this document. Heather, I don't know if there's anything you wanted to add or if other folks have questions.
I just want to say thank you publicly thank you for giving us this presentation. Trust me, everyone, that you should be very glad that you didn't have to suffer through listening to me try to explain it. So thanks, Jackie.
Of course.
Okay, thank you all very much for the presentation and for the hard work that was done on the revisions and legal issues subcommittee. I know that y'all worked hard on that, and it's a lot of tedious work, I'm sure. Is there any other comments or questions for either Jackie or for Heather?
Bill, I think we need to call for a vote regarding those recommendations to see whether or not the full committee would support the recommendations. My understanding is that because it's coming out of a committee, that serves as the motion. I don't know. Billy, does it need a second?
It doesn't, since it's coming out of a subcommittee. So you're moving in as the subcommittee chair, and we can move forward with discussion.
Okay. So we do have a motion on the floor. We don't need a second for it. Any further discussion on the motion to approve the changes as are listed in our 6-page document? Hearing no further discussion, Kim, if you would do a roll call vote for yeas and nays.
Yes, sir. Betty Budd. Tara Callahan. Yay. Darren Campbell.
Yay.
Jay Corpney.
Yay.
Bill Davis.
Yay.
Gary Frank. Beth Freshwater Smith. Yay. Michelle Hall.
Michelle Hall, yay.
Krista Hyatt.
Yay.
Ruby Brown Herring.
Yay.
Jennifer Knox. William Lassiter.
Yay.
Jeffrey Ledford.
Yay.
Kim Martin, Marty McGee,
Marty McGee, yes.
Carol McManus,
Yay.
Judge Rader,
Yay.
Mary Stansel,
Yay.
Heather Taraska,
Yes.
McKinley Wooten,
Yay.
Eric Zagra, roll call complete. But Eric, did you know you weren't unmuted? Eric, do you concur? Okay, thank you. Thank you. Roll call complete.
Okay, thank you, Kim. So the motion passes. Hearing no nays, so it's unanimous. Next we have on the agenda is the minimum age subcommittee. Judge Corpening.
Thank you, Chairman Davis. As an update, the minimum age subcommittee has met, I think, a total of 6 times, beginning in January of this year. Took a bunch of months off because of COVID-19, but then resumed the meeting in early September and have met regularly to look at the issue of making a recommendation to raise the minimum age. We have, courtesy of Aaron Hickey at DPS, we were able to look at what every state in the country does about minimum age and also about capacity to proceed. We heard from several subject matter experts and had as additional participants in our committee several people that are experts in the area of child development, psychology, brain development. Heard a presentation from Jackie Green, who assisted us along the way. We actually met for the most recent time at 11:30 this morning, and the committee voted to make a recommendation to this group to raise the minimum age to 10. There are some other pieces of that, and we were prepared to present a summary for your approval today. Immediately after our meeting this morning, Billy Laster got an email from Gary Frank, who asked for an opportunity to take our recommendations to the executive committee of the Conference of District Attorneys. And Billy and I talked immediately after that, and I feel like that's a great idea. Certainly would want the executive committee of the Conference of DAs to have an opportunity to weigh in, to express any support or concerns that they have. Heather Taraska did participate in some of our meetings. We had some additional participation from Rachel Larson, but the executive committee of the DAs had not weighed in yet. So we're going to ask that Billy and I have an opportunity to meet with the executive committee to explain the process we've gone through, some of the information that we've gotten from our experts, share our detailed recommendations. We've actually, thanks to Billy and Aaron and Jackie Green, we've got a statutory recommendation as well, similar to what you've just heard. But we feel like the DAs need to weigh in on it first. So I'm gonna stop with an update instead of Chairman Davis asking for a vote today. I'll ask that we be back on the agenda at the January meeting to make a presentation and to ask for a vote at that time. Billy, anything you want to add to that?
I think that's a good overview, and I know that there are quite a few people that are on the call today as participants that have been part of that working group, and we've had some outstanding advice from the North Carolina Psychological Association, from child development experts, as the judge has said, and we just really appreciate the expertise that has come in to help us with this process. And as Judge Corpening said, we're going to hold off as a privilege of the chair. Mr. Frank has asked that we give him a chance to talk to the executive committee of the DAs, and we want to make sure that we get them on board and part of the process. So we'll hold off until then. And I appreciate Judge Corpening's work on this. He's done a great job of leading the committee and getting us to a point where we can put together a recommendation, and we'll do that in January.
And I'm happy to answer any questions anyone has about our work. I want to add my thanks to the experts that worked with us. I mean, we had three PhD psychologists meet with us in virtually every single meeting at the Opera Insight. So we're so grateful to all the work that was done.
I'd just like to say that I'm grateful to you and to Billy for allowing the conference the opportunity to weigh in. My plan was to abstain if we were to call for a vote today. If possible, if I could participate in the meeting where you all explain the process, I'd love to do that. Thanks.
So, Heather, my plan was to ask you to do that since you've been involved in this one.
Okay, thank you all for the work on that, and I really appreciate Co-Chair Frank's input on that, and that I think is a very good idea. Is there any other groups or any other, I know we're well represented on this subcommittee, but on this committee, but is there any other groups that we feel like maybe we need to touch base with?
We'll do that, Bill, and Jeff Ledford. We may be reaching out to you to reach out to the Chiefs Association and also to the Sheriff's Association, Sheriff Campbell, just to make sure that any interest that you guys have on this issue would be taken into account. So I'll send out an email to both of those groups and let them know where we are and see if they would like for us to come meet with them or present to them about what we've come up with so far and let them look at those recommendations.
Very good. Any other input from the group? Okay. If not, then thank you very much for your work on that, Judge Corpening, and I'm sure we'll be looking forward to maybe being able to put that on the agenda for our next meeting, which is January the 5th. Moving on to our next agenda item, new business. Is there any new business that any of our members need to bring up?
I just have two quick things, Bill. We're going to be working on the report that we'll be looking at on January 5th. As you all know, on January 15th, we have to submit the interim report to the legislator from this committee. And so we'll be working on that report over the next month here. And so if there's input that you all have, we have all the resource things that were asked for last time. We'll include those things, but McKinley from the AOC and from the, as far as judges and DAs and ADAs and those types of things, if there are things that you all want us to look at, we can send back out the text that we had last time, and we'll do that to folks. But any additional recommendations that folks have as far as resources or those types of things that we want to consider at the next meeting so that we can include those in the report, please be thinking about what those are so that we can include those. The other thing that I'd like to do, just as a point of personal preference, privilege, is recognize Rachel Larson, who's been really helpful on a lot of this stuff. She's worked with the Conference of DAs and has been our contact with for juvenile issues. She just got, I don't know if I'd call it a promotion or not, but she just got moved up to the federal level to help out with issues on juvenile issues. And North Carolina will still be part of her area that she'll be covering. But I just wanted to recognize all the work that she's done. She's been on a lot of these committees and helped us with a lot of insight on developing this legislation. And so I just wanted to recognize her and thank her for all her work that she's done with this committee. And if you get a chance, if all of y'all could reach out to her and just congratulate her on her new job and thank her for all the work that she's done with us. Thanks, Bill.
Thank you, Deputy Secretary. Anybody else with any new business? Okay, hearing none, we'll move on to the public comment section. Kim, are you aware of any public comments?
There is one public comment from Rachel Larson with a conference of DAs. She is asking, is there a way to make the clerks responsible for communication of secure custody order rather than prosecutors?
Would Heather or Jackie, would y'all like to address that?
Jackie, do you remember if we had discussion around that, or Eric, Billy, anyone recall that?
We talked about it a lot, actually. I heard a lot of the folks on the subcommittee voice that they thought it was a responsibility reasonably housed with the prosecutor. I don't know if anybody else on the subcommittee wants to weigh in on that, but I feel like we did chat about that.
We did talk about it, and I guess I was remembering it a little bit differently. I thought that because there was some discussion about the clerk would be in the courtroom, and so the clerk would know that had occurred. I don't know.
Well, I think you're right, Judge Freshwater Smith. I think there was that discussion, but then there was also a discussion about some of these are going to be done not in court. That there's just going to be a deal between the prosecutor and the defense attorney. That it may not even. I mean, it may just be a signature that the Superior Court judge makes on the document, but the deal may be actually made somewhere else, not in the courtroom. And I think that's what I remember. If I'm wrong, I think that was what Judge McGee had said from the Superior Court side. But if I'm remembering that wrong, someone correct me.
You're probably right, but can that happen not on the record?
It can. It doesn't have to be a hearing. I mean, the court has no discretion. So once that joint motion comes in from the prosecutor and the juvenile's attorney, Superior Court is required to remand the case. There's nothing to talk about in a hearing once they get the joint motion. And in practice, and this is, kind of what I was referencing earlier, but, way more than that is on the agenda today. In practice, I think what it ended up looking like for folks is that the prosecutor and the juvenile's attorney agree to the remand before the case is even transferred in the first instance. And so they are literally like, the district court has to issue the transfer order, has to address the issue of conditions of pretrial release. The paperwork in the case moves to Superior Court with the joint motion, like already in hand, ready to roll. And the Superior Court is then signing an order and sending it all back to the district court, and it's largely been a pushing of papers because there is no decision for the court to make in that situation.
But, and again, this is sort of going with the question that I asked yesterday, because we were told there wasn't a Superior Court file made yet, and no number was assigned. So that sort of gets into this same thing, and I'm wanting some direction for my local folks, what we're supposed to be doing.
Yeah, LaToya might want to weigh in on that, but there is a rule of record keeping that tells clerks not to create a record until the period for appeal has passed, which is a 10-day window following transfer, right? Everybody has a right to an appeal for 10 days following the transfer of their case. But if that case is getting remanded, that issue of appeal is really moot. And on the remand, you have to expunge the record. That's the other thing that has to happen on remand. So there should be no, in the case of a remand, there should be no record left in the Superior Court because the statute requires that there be no record left. So what you asked me about yesterday, Judge, which we still haven't had a chance to talk privately about, but was a different situation, right? Where the case wasn't remanded, it was dismissed in the Superior Court. And my answer on that is a little bit different about what needs to happen, although it'd be interesting to hear what LaToya thinks about that, maybe offline.
Okay.
But the short answer to the remand question is there is no requirement for a hearing. And I think in practice it's been largely a pushing of papers from one court to the next.
Thank you.
Yeah, this is LaToya. I was just going to agree with what Jackie's saying about this process largely happening outside of the clerk's presence, which is actually what happens, which is traditionally what happens anyway with all juveniles. When an initial secure custody order is entered, that the clerk never has been the person to communicate the secure custody order to a court counselor or to a law enforcement officer. If law enforcement officer goes to a court counselor and makes the request, and the court counselor either contacts a judge, or if there's delegated authority, the court counselor can approve the secure custody order. But that process doesn't generally involve the clerk. So the way the proposed language is written for the remand cases pretty much tracks what's happening already with secure custody orders.
So the gist of it is the district attorney who has gone with the defense attorney made the motion, asked the judge, the Superior Court judge, to remand and to approve a secure custody order. And the DA is going to be taking that back to the clerk. Is that correct? Okay.
Okay, any further questions or comments about the public comment that we received? Any other public comment, Kim?
No, sir, that's it.
All right, thank you very much. Next steps, and our next meeting is going to be, we're going to schedule that for January the 5th on Tuesday from 10 to 2. And we are going to, again, I think, Kim, shoot for an in-person meeting if we are lucky.
Yes, sir.
Okay. Well, thank you very much for that. And here, if there's any other further information, I'm sure Kim will be sending that out to folks and update folks as to what our plans will be for January the 5th. But right now we're looking at January the 5th and having an in-person meeting at the Hammond Business Place, 10 to 2. And I think that's all of our agenda. So do I hear a motion that we adjourn our meeting?
Opening, so moved.
Okay, we have a motion.
Second.
Okay, we have a motion and a second. And all in favor of adjourning our meeting, say aye.
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 And look forward to seeing you in the future, hopefully.
Thank y'all.